Picture this. Your family loses you, and the very next week, they cannot touch a single dollar in your bank account. Not with a will, not with a notary, not even with an attorney standing next to them at the counter. None of it matters because none of it controls what happens to that money. Your bank's own paperwork does. And odds are nobody ever told you that. There is one free form that fixes this completely. Takes about 10 minutes to file, and most people have never heard of it for a simple reason. Nobody whose job depends on the current system has any incentive to bring it up. Today, I'm going to show you exactly why a will doesn't protect your bank account the way you think it does, the one form that actually does, and the 3 specific mistakes that quietly lock families out of money that was legally theirs. Before we go further, I'm not an attorney, and this video is for education only, not legal advice. Estate law varies by state, so verify your specific situation with a licensed estate attorney before acting. If that's useful, hit that like button. It helps this reach people before they need it the hard way. Let's get into it. Here's the part almost nobody explains clearly. Your will controls your physical property, your house, your car, your jewelry, the things sitting in your home. It does not automatically control your bank account. Your bank account is governed by a contract between you and the bank, and for decades, every state has operated under some version of a legal framework that treats that contract as its own separate track, completely apart from your will. What that means in practice? If you die without a named beneficiary on file at your bank, the account does not go to your heirs directly, it goes to your estate, and the moment that happens, probate opens automatically. The court-supervised process of validating your will and distributing what's left. Most states set a threshold somewhere between $50,000 and $100,000, cross that, and your family is now waiting on the court's timeline, not theirs. And probate is not fast. Most states require a mandatory waiting period, often 3 to 6 months, specifically so any creditor can come forward with a claim before a single dollar gets distributed. Meanwhile, the funeral bill doesn't wait. The mortgage doesn't wait. Nothing about grief comes with a financial pause button. Let me walk you through how this typically unfolds, because the pattern repeats constantly with families who genuinely did everything they thought they were supposed to do. Imagine a retiree, we'll call her Helen, who sells her family home, deposits the proceeds into a standard savings account, and hires an estate attorney to draft a thorough will naming her 2 children equally. She does this carefully, on purpose, and tells her kids everything is handled. What she doesn't realize is that her estate attorney drafted a will, a completely separate document from a bank beneficiary form filed at a completely different institution. Nobody at either office mentioned that the second form even existed. When Helen passes, her children bring the death certificate and the notarized will to the bank. The branch manager looks at the screen, looks at the will, and explains that without a beneficiary designation on file, the bank has no legal authority to release the funds, regardless of what the will says. The account is frozen, and the funeral bill comes due, and the family covers it themselves while a 5 or 6 figure balance sits behind a counter they cannot legally access, followed by months of probate court filing fees and an attorney's percentage cut before anything reaches them. Helen didn't make a careless mistake. She did exactly what most people assume is enough. That's precisely why this trap catches so many families who did everything right by the standards they were given. There are 3 specific situations that create this exact problem, and I want you to think honestly about which one might apply to you right now. The first is simply no beneficiary designation at all. You opened the account years or decades ago. Nobody asked. You assumed the will would handle it. It won't. The second is an outdated designation, and this one is more dangerous than having none because it gives you false confidence. You named someone decades ago, an ex-spouse, a parent who's since passed, a sibling you've lost touch with. And that name is still the one on file. Courts have consistently upheld the designation on the bank's form over a more recent will that says something different. The bank looks at its own paperwork, not your lockbox. The third is the joint ownership assumption, and this is the one with the most painful hidden cost. Many people add an adult child to their account as a joint owner, thinking it simply makes things easier if something happens. But the moment that happens, the law in most states treats that money as partly the child's immediately while you're both still alive. If your child is sued, faces a divorce settlement, or owes back taxes, your savings can become exposed to their liability. Not hypothetically, actually. A beneficiary designation avoids every bit of that. It gives the named person zero ownership or access while you're alive, and a clean, private transfer the moment you pass. If this is making you think about your own accounts right now, take a second and hit that like button, and pull out your bank statement while you're at it. Look for a beneficiary field. If you can't find one, or it's blank, that's worth fixing today. So here's the fix, and it really is this simple. It's called a Payable on Death Designation, or POD, sometimes called a Totten Trust, depending on the bank. It traces back to a New York court ruling from 1904 and has since been adopted in some form across the country. It is not a will. It is not a trust in the traditional sense. It's a direct instruction to your bank. When you die, this account goes straight to this named person. No court, no probate, no waiting period. When a valid POD is on file, your beneficiary simply brings a certified death certificate to the bank. The funds are released often the same day or within a few business days, not months. Every FDIC insured bank in the country is required to offer this, and it costs nothing to file because it isn't a product the bank profits from. It exists purely for you. If you have a brokerage account holding stocks, bonds, or mutual funds, the equivalent form is called a Transfer on Death Designation, or TOD, filed with your brokerage instead of your bank. And if you have retirement accounts, an IRA, a 401ki, those already operate on this same principle by law, but here's the catch. Most people filled that form out decades ago and never looked at it again. An ex-spouse from 1995 can still legally be entitled to collect the entire balance if that name was never updated, regardless of what your current will or divorce decree says. If you've got someone in your life who needs to hear this, send them this video. It could save their family months of exactly what we just walked through. Here's where most people, even after filing one form, still leave gaps. Each account needs its own separate designation. If you have 3 CDs at the same bank, each one needs its own POD filed individually. One form does not blanket your entire relationship with that bank. The same goes across institutions. Your checking, your savings, your brokerage account, and your retirement accounts all need to be checked separately. There's also the safe deposit box, which catches people off guard in an especially frustrating way. Federal regulations require banks to seal a safe deposit box the moment they're notified of the account holder's death. And that applies even if a family member has a spare key in hand. If your physical will is sitting inside that box, your family faces a genuinely circular problem. They need the will to open a probate case, but they need a probate order to open the box. The fix is simple and free. Add a trusted person as a joint renter on the box itself, so they retain access regardless of what happens to you. If you're finding this useful, consider subscribing. Every week I cover exactly this kind of thing, the rules that protect your money that nobody volunteers to explain. Here's your action list in order. Go to your bank this week in person or through your online portal and ask for the Payable on Death Beneficiary Designation Form. Every FDIC insured bank must provide it. Name a primary beneficiary using their full legal name and date of birth, since vague terms like my children can delay or complicate the payout. Name a contingent beneficiary too as a backup in case your first choice doesn't outlive you. Check every account separately, checking savings, each CD, each brokerage account. If you have a brokerage account, contact that firm separately and ask about a transfer on death designation. And if you have any retirement accounts, log in or call your plan administrator and confirm the beneficiary listed is actually still who you want, not whoever was listed when the account was opened years or decades ago. Make it a habit to revisit every designation every few years or after any major life event, a death, a marriage, a divorce, a new grandchild. None of this requires an attorney and none of it costs anything. It just requires doing it before it's needed, not after. Let's bring it together. Your will controls your physical belongings. It does not control your bank account. Your bank's own beneficiary form does. And without one on file, your family faces probate, court fees, and months of waiting for money that was already legally theirs. The fix is a payable on death or transfer on death designation, free, fast to file, and legally binding the moment it's on record. Check every account you hold, name a primary and a contingent beneficiary, and review it every few years. Again, I'm not an attorney, and this is for education only, not legal advice. Estate law differs by state, so talk to a licensed estate attorney about your specific situation before making changes. If this was useful, there's a related video on a benefit most seniors don't realize they're owed. It pairs naturally with making sure your money actually reaches the people you intend. It's right there on your screen. I'll see you in that one.